Does a personal representative need an attorney? So a personal representative, that's what we call in Florida the person who's in charge of administering a person's estate in probate. So when a person dies, if they have assets that have to go through probate, you got to go to probate court. There's likely going to be a personal representative. He or she's going to be in charge of, preparing the paperwork, signing the paperwork, going to court if necessary, and ultimately assisting in transferring all of those assets. Some states use the term executor or administrator. In Florida, we use the term personal representative, or PR for short. So do they need an attorney? Well, probably yes, because there is going to be what's called an oath of personal representative and designation of a resident agent, where basically the PR is affirming certain things, signing a notary saying that, they're over the age of 18, they're a resident of Florida, or if they're not a resident of Florida, then they're related to the person who passed away, they haven't been convicted of a felony. Basically some of the just standard requirements as to whether or not the person is qualified to be the PR. But then there's also a section where you're going to nominate, the PR is going to nominate somebody to be the resident agent for the PR, meaning that if the PR does something and maybe they're getting sued, or maybe there's creditors, they've got to be able to notify a resident agent of Florida, which is typically going to be an attorney. So I actually don't think I've ever seen a personal representative be a non-attorney and not have an attorney represent them. So basically, you just got a person, maybe the son of the person who passed away. I've never seen that. It might happen, but I think most courts in Florida are going to require you to actually hire an attorney if you got to be the PR. Now, there might be instances in a probate, a different type of probate, where, such as a summary administration or something like that, where you're not doing the full probate, and so you don't have to get named as the PR. In those cases, yes, the court might not require you to hire an attorney. But if there's a will and you've got to get named as the PR, or the PR is going to have duties and things that he or she has to do, then most likely, they're going to have to hire a probate attorney to assist them and stand in as the resident agent for the entirety of the probate process.